Thank you for taking the time to view this video. We're going to go on and look at a very important but often difficult subject, hate crimes and fair housing. One that I wish we would need to cover, but unfortunately these kind of situations do happen from time to time, and we need to be equipped in terms of how to report it and handle it from both a criminal and civil standpoint. We would like to thank Mishta for sponsoring this webinar and give a big thank you to Mishta for sponsoring this and many other webinars. We appreciate all that Mishta has done to sponsor our fair housing webinars. Our agenda presentation is going to be first define what a hate crime is. Why do we have hate crimes? We have crimes. Why do we need something like a hate crime on top of it? And then we're going to look at housing related hate crimes from a federal criminal prosecution standpoint. And then we're going to look at federal civil actions and civil fines that can be imposed when a hate crime incident occurs. Next, we're going to look at the First Amendment and housing related hate acts. Are there limitations as what can be challenged as a hate crime or hate act actually be protected under the First Amendment? And then we have developments on our state level, Michigan hate crime law, and it provides for criminal prosecution and civil claims as well. And then we'll finish by what steps should someone take in reporting hate crimes. First off, we need to define what a hate crime is. The Department of Justice has done the heavy lifting on this. And you can see, I kind of made a graphic from it from the DOJ's website. Hate crime is a situation where you have a crime and it's motivated by bias, and those two are combined to constitute a hate crime. So let's clarify what it's meant by hate. Hate doesn't mean rage, anger, dislike, disgust, right? Anger at somebody. No, I mean, that's a general term for what hate is. But in terms of a hate crime, in terms of how it's used here, is a bias against protected groups of persons, either based on the victim's protected class status, race, color, religion, national origin, etc., or a group of persons that have that protected class status or basis. Crime is defined, typically it's a violent type crime. It's an assault, murder, arson, vandalism, or threats to commit that kind of a crime, or asking others to commit those crimes. An important distinction here is that beliefs alone do not give rise to a hate crime. If it's merely beliefs alone, that's First Amendment protection, a protected activity, which we'll discuss in part 4 below. So the question is this: if crimes are already legal, why make it hate crimes, or why punish hate crimes? And here's the answer to that. By their nature, hate crimes do not just impact the immediate target or victim of the hate crime, but affects or attacks an entire groups of persons, communities, and sadly, even an entire nation. So that's what the hate crime does. Allowing hate crime to go is something that can spread to other members of a group. And that's where it becomes something that needs to be taken a bit more seriously than a general crime. Certainly not saying any crime is acceptable, it's not, but a reason for hate crimes, it's something that can spread and become very widespread if it's not challenged directly. So first off, we're going to look at housing-related hate crimes. What are federal criminal prosecutions that can be brought when there's a hate crime? And you can see I collected some of the statutes, not all of them. First one is really, it's under the Fair Housing Act, 42 United States Code 3631. And this is interference with the right to fair housing. You can see the protected class categories. I have those listed in the middle column. But it prohibits the use of force or threaten to use force to injure, intimidate, or interfere with, or attempt to do so with any person's housing rights because of their race, color, religion, sex, handicap, familial status, and national origin. Prohibits use of force or threaten force to injure, intimidate, or interfere with any person who's assisting other people or a group of people in exercising their fair housing rights. Violation is a misdemeanor. However, if there's aggravating factors present, such as bodily injury, using of dangerous weapons, and so forth, the offense is graduated up to penalties up to including life in prison. So they can really escalate greatly, right, depending when there's aggravating factors present. Other statutes include 18 United States Code Section 242, deprivation of rights under color of law, and it covers alienage status, race, and color. Prohibits an individual acting on color of law, meaning a governmental official, to prohibits willfully depriving a person of a right or privilege protected by the Constitution or laws of the United States, and is not necessary that the offense be motivated by racial bias or other animus. So it's a little bit broader than just simply covering hate crimes, but it certainly is a criminal provision that can be used to prosecute hate crimes. There is United States Code section 18 USC Section 247, damage to religious property, Church Arson Prevention Act, known as the Church, obviously, Arson Prevention Act from its name. And this is dealing with the religious nature of the property or race, color, ethnic characteristics of the people associated with the property. And you can see it prohibits intentional defacement, damage, or destruction of religious real property because of the religious nature of the property, or obstructing someone or a person or group of persons in the enjoyment of or exercise of their religious beliefs, intentionally defacing, damaging, or destroying any religious or real property because of race, color, or ethnic characteristics of any individual associated with the property, regardless of any connection to interstate or foreign commerce. It's punishable by a misdemeanor, and if there's aggravating factors present, then it can be subject to graduated penalties up to including life in prison or death, meaning a death penalty on this one. Then there's also 18 United States Code Section 249, the Matthew Shepard and James Beard Hate Crimes Prevention Act. And you can see actual perceived race, color, religion, national origin, gender, sex orientation, gender identity, or disability. Prohibits willfully causing bodily injury or attempting to cause bodily injury with a dangerous weapon. That is certainly a hate crime act. And it's not limited to housing. It's any type of situation would be covered under this statute. And it also has the same dealing with aggravating factors, which provide for what? Enhanced criminal penalties up to any term of years or life. So those are the main ones. There's some examples of them. This one is dealing with crime based on color. 6 black men assaulted and seriously injured a white male and his Asian male friend as they were walking through a residential neighborhood. Witnesses stated that the victims were attacked because they were trespassing in a quote-unquote black neighborhood. In disability scenario, an example of one would be a group home for persons with psychiatric disabilities, and they're transitioning back to the community, and their property was the subject of reported arson. Investigation revealed that the neighbors expressed concerns or negative comments about the group home in town meetings, were angry to have the house located in their community. Shortly before the fire occurred, a witness was heard a man state, "I'll get rid of those crazies, I'll burn them out." 12 persons, including patients and staff, suffered second and third degree burns. Another one, gender identity, a transgender woman walking down the street near home, 3 men walking toward her said, "Hey, what's your problem, huh?" She kept walking, trying to ignore them. However, as they got close, one yelled, "We don't want no queers in this neighborhood," and the second one knocked her to the ground. There's some specific examples going under the Fair Housing Act for intimidation, for hate act under the Fair Housing Act, 42 United States Code 3631. In Cincinnati, Ohio, a man destroyed a rental home owned by an interracial couple. He sprayed the paint walls with racial epithets and drew images of swastikas. He also turned on the gas stove in the upstairs kitchen, poured paint into burners, and attempted to remove a smoke detector above the stove. That was found to be a violation. In a city in Mississippi, men burned a wooden cross to threaten to intimidate residents of a predominantly black community. In Garden City, Kansas, 3 men plotted to detonate a bomb in an apartment complex where Somali Muslim immigrants lived. They planned to obtain vehicles, fill them with explosives, park them around the apartment complex to create an explosion, certain to level the building and kill its occupants. In Los Angeles, California, a group of street gang members firebombed residents of 4 black families during the night. They pre-selected their targets, smashed windows on their apartments, and then threw Molotov cocktails into their residences. They knew that doing so while the family slept would create a substantial likelihood of causing serious bodily injury. Criminal outrageous. But there's also housing-related hate acts that give rise to federal civil actions and civil fines. It's worth going through it so that people can understand which sections apply and what the penalties are. First, what is a housing-related hate act in terms of the Fair Housing Act and civil liability? There is first retaliation in violation of Section 818 of the Fair Housing Act, and it's codified at 42 United States Code Section 3617, and it involves actual violence, assault, bodily harm, and or harm to property or threat of same. And that gives rise to civil liability as a housing-related hate act. So here's Section 818 of the Fair Housing Act, Section 3617. Says it shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or account of his having exercised or enjoyed, or account of his having aided or encouraged any other person in the exercise or enjoyment of any right guaranteed or protected by sections 3603, 3604, 3605, or 3606 of the Fair Housing Act. 3603 is probably a mistake, but the general fair housing rights are in 3604, 3605, and 3606. So if someone is exercising their rights, attempting to exercise wrong to coerce, intimidate, threaten, or interfere with any person in doing so. The HUD regulation implementing this provision always generally will start, and it does here, most HUD regulations, by quoting the statute, which it quotes in Part B, quotes 3617, but it lists examples of conduct that would be a violation of this provision. And here it's subsection C1, coercing a person either orally or in writing or by other means to deny or limit benefits provided in connection with the sale or rental of a dwelling because of, you see the protected class categories. And also residential real estate related transaction has to do with a financing transaction. Someone is going to finance the purchase of a home, or could even be vacant land that's going to be used to construct a home or a residential dwelling. Subsection 2 is threatening or intimidating or interfering with persons in their enjoyment of a dwelling because of the race, color, religion, sex, handicap, familial status, or national origin of such persons, or of visitors or associates of such persons. When it says handicap, that's the old language that was used in the Fair Housing Act in the 1988 amendments, and it is carried forward in the HUD regulations. It's synonymous with the more common and acceptable term disability. A couple of additional sections. Conduct made unlawful, threatening an employee or agent with dismissal or other type of adverse employment action, or taking adverse employment action, right, in an effort to have that person be involved in restricting the sale or rental of a dwelling or receiving information about available dwelling or housing opportunities because of the protected class status of any person inquiring or seeking housing or any person associated with that person. Again, it could be a white person seeking housing and then they're being threatened or retaliated against because maybe they have a black spouse or friend or person with a disability. So it doesn't necessarily have to be the actual person. If there's anybody involved, or they could have a minority real estate agent and they get adverse action taken against them. But this one, subsection 3, if you look at it closely, it overlaps with employment discrimination, Title 7. This kind of conduct would be also subject to being challenged civilly as a violation of Title VII, forcing someone or taking action against an employee or threatening an employee because they refuse to participate in discrimination. Subsection 4, intimidating or threatening any person because that person is engaged in activity designed to make other people aware of their rights, fair housing rights. Meaning if someone is giving a fair housing training program and they come out and their tires are slashed, that would be an example, but there are other examples as well. Doesn't necessarily have to be someone who's actually personally exercising fair housing rights, but as long as you're taking steps to make other persons aware of what their fair housing rights are and they're intimidated or retaliated against, that would be a violation. Also, subsection 5, retaliating against any person because that person has made a complaint. If they make a complaint, that means file an administrative complaint with HUD, state, local agencies. Sometimes they're at the state level. It can also be at the county or civil level. If they file a complaint, administrative complaint, or they file a court complaint and retaliate against, that's a violation. It also protects people who testify, assist, or participate in any manner in a proceeding under the Fair Housing Act. And the last one is retaliating against any person because that person reported a discriminatory housing practice to a housing provider or other authority. So what are the civil fines? As necessary to vindicate the public interest, civil fine may be awarded against a respondent in administrative action, be by a HUD administrative law judge. It can also, civil fines can be imposed against a defendant in a civil action brought by the Department of Justice. What are the amounts? When the Fair Housing Act was originally enacted, it was $50,000 for the first violation, $100,000 for any subsequent Fair Housing Act violation. Now, Congress in 1990 passed the Federal Civil Penalties Inflation Adjustment Act, and it got amended in 2015. So the current amount gets adjusted for inflation each year. It's $127,000 for the first violation, $255,000 for the second. It doesn't mean a court or administrative law judge would have to impose that high of an amount, but it gives them the discretion, the right to impose civil fines up to that amount for a first and second violation. Basically, it's determined by the facts of the case and the facts that are proven at the trial or hearing as to what the amount should be. There's also amount of civil fine in HUD administrative proceedings. So what are the civil fines in fair housing cases? It's necessary to vindicate the public interest. A civil fine may be awarded against respondent in administrative proceeding before HUD or defendant in a civil action brought by the Department of Justice. So when the Department of Justice brings a federal court action in court, the Fair Housing Act originally provided for $50,000 for the first fair housing violation and $100,000 for any subsequent second, third, fourth violation. Congress also passed Federal Civil Penalties Inflation Adjustment Act in 1990. They amended it in the Bipartisan Budget Act of 2015. So the current amounts as of March 2025 are $127,983 and $255,964. In HUD administrative proceedings, the Fair Housing Act originally provided for $10,000 for a first fair housing violation, $25,000 if the respondent committed one previous discriminatory housing practice in the prior 5-year period. If the respondent committed 2 or more discriminatory housing practices in the prior 7-year period, the civil fine would be up to $55,000. When I say the civil fine amount, it doesn't mean those amounts have to be awarded. It gives the administrative law judge or court judge in federal district court the discretion to award up to that amount. And again, using the Federal Civil Penalties Inflation Adjustment Act and the amounts as of March 2025 are $25,000 for the first fair housing violation, up to $63,991 if the respondent has committed one previous discriminatory housing practice in the prior 5-year period, or $127,000 if they've committed 2 or more within the prior 7-year period. Problem why this isn't really exercised that much, because many of the cases are resolved with a non-admission of liability. If the evidence is strong, a consent judgment should be entered, and with a non-denial of liability. That way it will count as a first discriminatory housing practice. If it's a standard non-admission of liability, then when another discriminatory housing practice occurred, it will count as a first violation. It should not be automatic that they're allowed to do a resolution with a non-admission of liability. I don't believe that's in the public interest. So what factors are used to determine amount of the civil penalty? Right? You look at first whether respondent previously committed an unlawful housing discrimination act. Take a look at the respondent's financial resources, the nature and circumstance of the violation, degree of that respondent's culpability. There could be several respondents involved. How culpable was the particular respondent? The goal of deterrence, set an example for others so that they won't engage in that practice, and other matters that justice may require. Housing-related hate acts provide for enhanced penalties under factors 3, 4, 5, and 6 mentioned previously. Administrative law judge would take into consideration. These are factors that are in favor of imposing the maximum civil penalty of $25,000 for first offense, $63,000 for a second, or $127,000 for 2 or more. whether respondent has engaged in a housing-related hate act. Housing-related hate act consists of any act that violated 818 of the Fair Housing Act, involving or accompanied by actual violence, assault, bodily harm, or harm to property, intimidation, coercion, with such elements or the threat of doing so. Other civil claims pertaining to housing-related hate acts include 42 United States Code, Section 3604 or 804C of the Fair Housing Act, prohibition against discriminatory statements. 42 United States Code, Section 1981, discriminatory denial of contract rights. Section 1982, discriminatory denial of property rights. And then 42 United States Code 1983, denial of rights, privilege, or immunities secured by the Constitution and laws of the United States. Here's a couple examples. An older HUD administrative law case, HUD versus Hope. Complainants were a black family. They were looking to purchase a home next to the home of the respondent, Mr. Hope, who is white. After complainants completed their tour of the home, respondent, his voice began to indicate anger, asked the Keys, the black home purchaser, prospective purchaser, why he would want to live there. Keys said, oh, it's a quiet street in a neighborhood, and in a quiet neighborhood, a nice place to raise children. Then Hope said words to the effect, yeah, it is an all-white neighborhood. And then he asked Mr. Keys, why, man, do you want to move here? It's an all-white neighborhood. We don't want blacks here. That's why my wife had to go hold the dogs. They were going to go crazy and don't like blacks either. Respondent, Mr. Hope, continued to ask why they'd want to live there, referring once to the neighborhood as a redneck neighborhood. He also turned around, pointed to his neighbor's house, stating his neighbor, who owns a gun shop, feels the same way I do. You see the threats involved there. At that time, respondent, Mr. Hope, started backing away while continuing to make those kinds of statements. He waved his arms and pointed at the dogs. He pointed at the neighbor's house, said he was going to go over and tell the neighbor who owns a gun shop. The Keys, as a result of that, were frightened and departed. The real estate agent for the Keys remained in the house while the Keys and the neighbor, Ms. Nesbitt, left the house to tour the yard. She wasn't aware of the confrontation until Ms. Nesbitt, the neighbor, knocked the door and told her she had better come out because the neighbor has just threatened the Keys. As she came out of the house, meaning the real estate agent, Hope, the respondent, began shouting at her. He was visibly angry, waving his hands and yelling. He said to Ms. Beard, the real estate agent, did not know why blacks wanted to move into the neighborhood. He did not like blacks. His dog did not like blacks. His neighbor did not like blacks. And his next door neighbor, who owned a gun shop, did not like blacks, right? And he was shocked that the Keys, a black family who tended to move in the house next to his. Miss Keys was upset, shaking, and crying. It's easy to understand why. That evening, Keys phoned their agent, who in turn phoned the other sellers. Agent report that they could not buy the house because of the confrontation with respondent Hope earlier that day, right? They said they can't live there. They fear for their lives and well-being. To live next door to a person who exhibited such hatred and who would instill fears in others. See how disgusting this was. They also didn't want to sign away their lives, their children's lives, and family to a lifetime of threats, insults, harassment, and possibly death. Awful. Following a hearing, administrative law judge entered a permanent injunction against Hope, prohibiting him from discriminating against the Keys, Beard, the agent, and their respective families, awarded damages the amount of $126,900 to the Keys and $8,140 to the real estate agent who was unable to complete the sale. The administrative law judge also imposed a maximum civil penalty at that time of $11,000 based on the finding of a housing-related hate act. Good result. Sad situation. Another housing-related hate act before HUD was HUD v. Wilson. Respondent Wilson did business as Alpha HQ, and an organization further goals of the white supremacist movement. He created a website, pictured complainant's photograph with a caption that said, complainant, I'm not sure if they intervened or not, with a caption that said, traitor, she's a race traitor, should be aware that traitors like this should be aware for in our day, they will be hung from the neck at the nearest tree or lamp post. Immediately above the complainant's picture, the website showed an animated photograph image of the Reeksburg Human Relations Council where the complainant worked, exploding into flames. Next to the picture of the flames, it said the Reading Berks Human Relations Council. This is the office where plans for additional race mixing and integration are planned. There was an interview with a news reporter, and the respondent Wilson reiterated the threat. This threat was actually made against the complainant's daughter that was posted on the website. Ms. Khan asked him whether he'd ever hang her daughter from a tree. He responded, in our time, yes. In an interview with FBI agents, he expressed pride in his website and the fact that it had been visited by 97,000 people in the last 3 years. Disgusting. And the purpose of the website was to further goals of the white supremacist movement and to make known to anyone interested in the movement their ideals, as well as the identities of those persons who were against them. So what happened, sometime in the summer of 1988, complainant became aware that Wilson made changes to the website. On the modified site, he described complainant's daughter as a mongrel. He also added a recipe for a bomb with a kind of a weak disclaimer. The organization does not wish to imply individual mentioned above article felt this website be harassed or injured in any way. For legal reasons, we must make this statement. However, look what it puts here. If those people are still alive when the political tide swings back to the right, they'll find our wrath something to be dealt with. So he also promoted his website as being in high regard for technological advances, including voiceover and animation. Mr. Wilson devoted a significant amount of time defining a dramatic image of an explosion he could incorporate into his website, and it depicted overt violence and specified the attack against the complainant. It included bomb-making recipes from popular white supremacist literature, including the Anarchist Cookbook, highlighted recipe used in the bombing of the federal building in Oklahoma City. And I go through the list of it, but you get the idea. He placed complainant's photograph and the image of her office blowing up in the main frame on the second page of the website, and a visitor to that website had to pass through that frame to continue exploring the site. Right? Awful. What did the court find? It was the equivalent, the website was the equivalent of burning a cross on someone's property. It conveyed a clear message. Complainant's presence in the community is not acceptable. She's watched, and white supremacists in the community should know that she has been targeted. It conveyed the hope, if not expectation, other white supremacists would take some specific action to harm or intimidate the target. Awful. Wilson targeted complainant as an enemy of the white race. He targeted her as a race mixer because she had a biracial child. Once white supremacists target an individual, harassment in the form of cross burnings, receipt of emails, telephone calls, or dead animals usually follows. Property damage, assault, attempted murder, or murder may also follow. And then at the bottom, other white supremacist types, racial threats and harassments are listed in the administrative law judge decision. I did not list all of them. It's awful. And these incidents had a profound impact on the complainant and her daughter. Default judgment was entered against respondent Wilson and his organization, Alpha HQ. The judge entered injunctive relief, imposed a maximum civil penalty, and awarded damages to the complainant and her daughter in the amount of $283,000 against Wilson and $827,000 against his organization, Alpha HQ. Just awful. So it often arises in these cases. Can a First Amendment challenge be brought to a housing-related hate act? And here is, are the challenge actions, are they purely discriminatory conduct, or is it protected speech? HUD has guidance. It got promulgated or reissued from year to year, and it remains in effect. HUD FHEO 2015-1, I'll read it. Substantive and procedural limitations on the filing and investigation of fair housing complaints that may implicate the First Amendment. So what is First Amendment protected activity? Defined as absent, not including the First Amendment activity does not involve force, physical harm, or a clear threat of force or physical harm to one or more individuals. Provided that's not present, the First Amendment protected activity involves public activities directed toward achieving action by a government entity or official. Even where hostile, distasteful, and or bigoted speech occurs, can be part of a robust discussion of public issues. Again, First Amendment protected activities involve what? Communications with the public at large or with the government. such as distributing flyers, pamphlets, brochures, posters, or other written materials, quote, to the public at large, not directed to a specific individual or group of individuals, holding open community or neighborhood meetings, writing articles or letters to the editor, making statements in a newspaper, conducting peaceful demonstrations, testifying in public hearing, otherwise communicating directly with a government entity concerning official government matters. Those are all First Amendment protected activities. There are two cross-burning cases by the U.S. Supreme Court, which are really still the standard when it comes to First Amendment protected activity in a housing context. In RAV versus City of St. Paul, in the pre-dawn hours, petitioner and several other teenagers assembled a crudely made cross, taping together broken chair legs. They allegedly burned the cross inside the fenced yard of a black family that lived across the street from the house where petitioner was staying. The court noted that the conduct could have been published under any number of laws. You can see the case arose out of Minnesota, St. Paul, Minnesota statute providing for up to 5 years in prison for terrorist threats, arson, 5-year penalty, criminal damage to property. So there are various statutes that prohibited that kind of conduct. The petitioner was a juvenile at the time. He was charged under St. Paul's bias motivated crime ordinance, which says whoever places on public or private property a symbol, object, appellation, characterization, or graffiti, including but not limited to a burning cross or Nazi swastika, which one knows has reasonable grounds to know arouses anger, alarm, resentment, or others on the basis of race, color, creed, religion, or gender, commits a disorderly conduct, shall be guilty of a misdemeanor. All Supreme Court justices found the ordinance was unconstitutional. Reason for it, right? He wrote for the majority, say the ordinance prohibited only those fighting words that insult, provoke violence on the basis of race, color, religion, or gender. The ordinance was invalid, involving on content and viewpoint discrimination. First, as to content discrimination, displays containing abusive invective, no matter how vicious or severe, are permissible unless they are addressed to one of the five disfavored topics. Those who wish to use fighting words in connection with other ideas to express hostility on the basis of political affiliation, union membership, or homosexuality are not covered. First Amendment does not permit St. Paul to put special prohibitions on those speakers who express views on disfavored subjects. So it's content discrimination. St. Paul restricted the content of some statements, but not others. There's also viewpoint discrimination. Displays containing some words, odious, racial epithets, for example, would be prohibited to proponents of all views, but fighting words that do not invoke race, color, creed, religion, or gender, or aspersions upon a person's mother, for example, would seemingly be usable, and the play cards of those arguing in favor of racial, color, etc., tolerance and equality, but could not be used by that speaker's opponent. So again, the concern the court had is that there was not a prohibition of fighting words that are directed at certain persons or groups, and which would be facially valid, or rather prohibition of fighting words that contain message of bias motivated hatred, and in particular messages based on virulent notions of racial supremacy. And the reason, according to the majority, Justice Scalia, why fighting words are categorically excluded from the protection of First Amendment is not based on their content, or whether content indicates a specific idea, but that their content embodies a particularly intolerable and socially unnecessary mode of expressing whatever idea the speaker wishes to convey. Should be noted that petitioners who engaged in the cross burning were ultimately convicted of violating 42 United States Code Section 3631 and other federal statutes. That's the criminal provision as to interference under the Fair Housing Act. So they didn't get off because the court invalidated the City of St. Paul ordinance. They still were found liable under the Fair Housing Act. The second case, Virginia versus Black, it was a violation. They were convicted of violating Virginia's cross burning statute. You can see the statute quoted here. Any such burning of a cross shall be prima facie evidence of an intent to intimidate a group, person, or a group of persons. The court held that while burning a cross does not inevitably convey a message of intimidation, Often the cross burner intends that the recipients of the message fear for their lives. And when cross burning is used to intimidate, few, if any, messages are more powerful. This time, the court found that the statute, in this case Virginia statute, did not violate the First Amendment insofar as it bans cross burning with intent to intimidate. Unlike the statute at issue previously in the REV decision, the Virginia statute here does not single out for opprobrium or condemnation only that speech directed toward one of the specific disfavored topics. It doesn't matter whether the individual burns a cross with intent to intimidate because of race, gender, religion, or because of the victim's political affiliation, union membership, or homosexuality. So those are still the two leading decisions when it comes to First Amendment protected activity. Court concluded, Justice O'Connor, in a concurrence, prima facie provision rendering the statute unconstitutional. There was a prima facie provision which says that if the cross burning, it's prima facie evidence of a violation. That part was thrown out. History of cross burning doesn't always indicate an intent to intimidate. So there's times where a cross burning can represent protected speech, but often when it's done to target a particular family or housing part, then it does indicate unlawful conduct that would not be protected under the First Amendment. HUD has guidance and some examples that HUD uses. Safari versus Pinellas County, the court held that defendants know threatening to break plaintiff in half if he did not leave the neighborhood, hitting plaintiff's truck, shouting obscenities, spitting at them would clearly constitute of coercion and intimidation. That is not First Amendment protected activity. People's Helper Foundation versus Richmond. There was a course of harassment which included neighbors organizing in front of a group home for persons with disabilities, using derogatory language referred to the occupants and photographing occupants and volunteers would be actionable and not be First Amendment protected activity. The Tal versus Werner case, one can imagine a moderate level intentional and persistent nuisance behavior motivated by racial or religious animus directed at a victim over a sufficient period of time that might prove so disruptive and coercive as to warrant relief under 3617. HUD v. Hope, we talked about that earlier. We talked about that one. HUD v. Gittleman, finding violation of 3617 because respondent repeatedly made racial slurs within earshot of minor complainants, and the First Amendment defense was rejected in that case. HUD v. Johnson, respondent violated 3617 when she repeatedly made within earshot of complainants racial slurs and threats to kill them. She appeared in media making threats against blacks and distributed to one of the complainants promotional materials from the nationalist movement, which is dedicated to beating back minorities. HUD v. Weber, violation of 3617 when she descended from her porch and told complainant that his people could not live on her block, pointed at the complainant while saying there would be trouble if he moved next door, and threatened to block the common driveway. Michigan has enacted a new ethnic intimidation statute. You can see here it has both civil and criminal coverage. It's Michigan Compiled Law, Section 750.147B, ethnic intimidation. You can see the protected class categories that are covered: race, color, religion, sex, sexual orientation, gender identity or expression, physical and mental disability, age, ethnicity, national origin, or association with any of these groups. Person is guilty of a hate crime if the person maliciously and intentionally does any of the following: uses force or violence against an individual, causes bodily injury to another individual, stalks another individual, damages, destroys, or defaces any real or personal property, makes a true threat to engage in any of the conduct listed above. Criminal punishment is up to a felony up to 2 years and a fine of up to $5,000, but there's graduated penalties. It also, kind of unusual, provides for an alternative sentence such as community service to enhance an offender's understanding of the impact of the offense upon the victim and the wider community. Interesting thing, it provides for a civil action. Relief includes injunctive relief, treble 3 times the actual damages, including damages for emotional distress, or $25,000, whichever is greater, and reasonable attorney fees and costs. You can see pretty significant civil relief provisions. Now, they are careful to note in the Ethnic Intimidation Statute that it does not enjoin or meant to stop individual's exercise of the constitutional right to free speech. So here's an example, and this is from our website. Black woman or daughter sue former white neighbor for KKK flag display and other threats. You can see the picture of the flag that was displayed in Grosse Pointe Park. The flag was only visible from the respondent or defendant's home and could then be viewed by the plaintiff, the Dingus's home. You could not see it from the street. So what happened is we received a discrimination complaint from our center. We received it. Dingus, she's a small business owner, lived in a Grosse Pointe Park home since 2011. In 2017, Mr. Wilding moved next door, and there was a narrow 5-foot walkway separating the two homes. We've got pictures of that in our office. And then for approximately December of 2017 until April 2021, it's quite a lengthy period of time, Mr. Willie engaged in the following acts. He hung a KKK visible empire flag, which we just showed previously, visible only to Ms. Dingus and her family. He placed a full gas can in the recycling bin. He discharged a gun on multiple occasions in the middle of the night. He prevented Ms. Dingus from entering a shared walkway between his home and hers because staring at her in intimidating, kind of threatening fashion, and threw garbage in front of their home. Ultimately forced Ms. Dingus and her family to move out of the home in December 2021. And after receiving the complaint, we referred the complaint to the Civil Rights Litigation Initiative at the University of Michigan Law School. The federal court complaint, it's on a reference on our website, has greater detail on it as well. The court recently denied a motion to dismiss, found that the allegations raised would constitute a violation of the Federal Fair Housing Act. So what theories were alleged? 42 United States Code Section 1982 that deals with property rights, and it was originally enacted part of Section 1 of the Civil Rights Act of 1868. It says all citizens of the United States have the same right in every state and territory as enjoyed by white citizens who inherit, purchase, lease, sold, hold, and convey real and personal properties. And that does prohibit racial harassment, housing related, if it's a racial harassment, violates Section 1982. The case also has a claim under Michigan Ethnic Intimidation Statute, which we talked about. They also included claims for intentional infliction of emotional distress and negligent infliction of emotional distress. So that's an example of how it can be brought. That case is still pending, not been concluded yet. It will be interesting to see that case as it progresses to U.S. District Court. What procedures should people do in reporting hate crimes? What's the best way to report a hate crime? First off, why report them? The DOJ lists that the experts estimate there's about 250,000 hate crimes each year between 2004 and 2015. Shockingly, the majority of these were not reported to law enforcement. So why should it get reported? Because hate crimes affect not only the victim or immediate target, but affect entire groups of persons. And from the DOJ website, when there's force or threat of force, guaranteed with the rights protected in the Fair Housing Act, the Department of Justice can bring criminal prosecutions. You can see the things that can include cross burnings, arson, firebombings, vandalism of property, written and oral threats, assaults on persons to exercise their fair housing rights, and they can make claims directly with the criminal section of the Civil Rights Division. They can also file complaints with HUD. We receive them as well. There's a map of the Michigan Fair Housing Center, and you can make a complaint with one of the fair housing centers. We have all the counties covered. Complaints can also be made with the Michigan Department of Civil Rights or with a variety of options in reporting it. The Dingus case, which we talked about earlier, they contacted HUD. HUD then had the Dingus contact our office. We investigated and found Michigan U of M Law School Civil Rights Initiative that then filed the case in federal district court. Certainly that's an option. We take these complaints, as other organizations do, quite seriously. I want to thank you very much for taking the time to listen to this overview of housing related hate crimes. I hope it's been helpful to get an understanding of the criminal and civil provisions that are implicated in housing related hate crimes. an understanding of what's protected, what's not protected under the First Amendment. Please note we have other videos that are related to this subject. Our most popular video is damages in fair housing cases. What is the case worth? What kind of damages can be awarded? And then we also have a video on basics of fair housing enforcement, what to do when you experience housing discrimination. Thank you for viewing, and I hope this short presentation has been helpful to give you a good understanding of what to do and how to identify hate crimes when it comes to housing. Thank you so much.